Chief Justice and Chairperson of the National Commission of Administrative Justice and the President of the Supreme Court of Kenya, the Deputy Speaker of the National Assembly, the Cabinet Secretary for Interior and Director of Public Prosecutions, the Vice Chair of the Council, who I know is represented by his able deputy, the Attorney General, the chairpersons of the Council, I thought he was going to be there, of governance, the representative of the EU, the Diplomatic Corps, the Permanent Secretary of Correctional Services, allow me, the Inspector General of Police, allow me to adopt the protocols, lest anyone feels I've left them out. Let me just say, I fear you all. Good morning, everyone. Good morning. Advancing access to justice for vulnerable persons demands that we move beyond declarations of goodwill to deliberate, coordinated action. The Constitution of Kenya guarantees justice that is not a privilege for the few, but a right for all, accessible, affordable, and responsive to the lived realities of the people. Yet for many Kenyans, justice always feels distant. Imagine the single mother who cannot afford bail, the child lost in the remand system that does not, and no one feels like no one sees him or her, the protester brutalized for demanding accountability, the family that spends years in court seeking justice because their kin disappeared, the families that continue to come before courts, but their cases take years and years. This is the gap that we must see how to close between the promise of justice and the actual experience. As Nelson Mandela reminded us, overcoming poverty is not a gesture of charity, it's an act of justice. In the same spirit, ensuring that every Kenyan, regardless of wealth, gender, or circumstance, can access justice is not benevolence. It's the fulfillment of our constitutional duty. According to World Bank report, the voices of vulnerable groups who are most impacted when justice fails are not often heard in discussions, and particularly when we are talking about justice systems. We fail to see them at the table, speaking and also sharing their experiences. So that is something that we must start as a reflection. When you look at our legal framework, the Constitution gives us the best background, giving us the anchor in how we can protect vulnerable groups and persons of special needs. However, we continue to see also the various statutes that we grapple with. There is nothing on the question of which institution is responsible for legal literacy. When we talk about access to legal aid service, we've left it mostly to the Office of the Attorney General and various small groups and institutions to run the same. However, we have not budgeted for the same to ensure that we actually see this as a lived reality. Legal aid is often not prioritized, looking at the importance in which it impacts upon the society. When we look at our judicial structure, access to courts by vulnerable persons continues to be a challenge. If you've gone around the country, particularly, I think the Chief Justice, you've been going around meeting the different branches. If you have had the opportunity of going to Kericho courts, I shudder in fear how I'm going to meet my members when I go to Kericho courts, because when it rains, it floods. And they will not want to see my face, because these are promises we have been pushing that we cannot see as realities. You go to various courts, even access to bathrooms, particularly for old people or persons with wheelchairs, they cannot access. They cannot get there. People with children, there are no toilets for children. So where do you expect these children to access? Just basic needs, basic services for them to be able to access and go to our courts. Even when we talk about virtual courts, how are virtual courts being made accessible for special needs and vulnerable groups? You either have to be literate, you have your own devices and gadgets, but what about those who cannot they cannot read by seeing, or the blind. Do we have services that meet those particular needs? And also for different vulnerable groups, have we encompassed as we come up with these systems? We need to start looking at how we make access to justice a reality. Costs related to access to justice. I think this is a discussion we've had mostly in light of witness protection, but it's still a problem. Transport to come to court, particularly cases that take years and years. Somebody would rather fold up and say, I'd let go of this case, because if I have to pay 200 shillings every single time to come to court, only to hear there's an adjournment, the other side is not ready to proceed. This is money that they have spent. 200 shillings they would have used to buy seeds, to be able to plant and get something that they're going to eat or put food at the table. We need to look at justice in that simple, rudimentary term. What does it mean for those groups? Costs related to filing, particularly certain public interest matters, family matters, gender-based violence matters. We've seen efforts by the courts to have specialized courts for GBV and SGBV cases. However, we need to look at, particularly for vulnerable groups who cannot afford. I remember this year we had a back and forth with the courts, particularly on the bail and bond terms, that were going to be quite difficult for vulnerable persons. When you're told to go to the chief to give you a letter so that you can get bond, which chief will give you that letter? First of all, the chief will demand money from you. So what are you telling that vulnerable person? That access to justice is not available for you because you do not have money. And so those are areas we need to look into. Cultural structure. I think we normally talk about so many things, but we forget the impact of culture in our country. Franca Viola, a Sicilian woman famous in the 1960s, for having refused a rehabilitating marriage. Her case scenario was that her rapist kidnapped her and held her hostage for over a week and repeatedly raped her. And the law allowed for rehabilitating marriages, that once you're married, that you cannot prosecute. However, her refusal led to the prosecution of the rapist and in time led to the repealing of that law. What I'm saying is that we may not see the impact of the small things we are doing, but eventually we will see the impact that will come out of it. Today in our culture, in 2025 in this country, we continue to see targeted aged killings, where all people accused of witchcraft for the purposes of killing them and taking away their land, so that someone who is tired of waiting for the death of their aged grandmother or grandfather to die, so that they can quickly inherit. Raping of old people, rise of teenage pregnancies, the question of the Council of Elders. How do we look at working on the bad things and improving on what is good? By virtue of the task force on gender-based violence and femicide that was hosted by the Cabinet Secretary of Interior and also the Ministry of Gender, I had the opportunity of learning some of the bureaucracies of our laws and what the impact it does. Because of the question of filing fees, long periods of time before you can appear in court, and also the bureaucracies of long court cases, we see people going to the Council of Elders that is facilitating illegal settlements. We continue to see compensation for killings, compensation for rape, compensation for child labor. We see children who once raped, particularly in certain cultures, you lose the ability to go to school, the ability to have a future, and you're deemed, particularly as a young girl, you're no longer of value, that you're thrown away to either child labor or child abuse, because now you have no value to your father because you have been violated. And so because of bureaucracies of our justice system, we continue to see people facing a lot of injustice. Today, as we launch this report, we ask ourselves honestly, what are the barriers that keep the poor, the detained, the displaced, or the marginalized from reaching justice? And what will it take to unblock them? Access to justice is not confined to the courtroom. It begins with the police officer who chooses restraint over brutality, the police officer who offers to listen to somebody who has come to report a sexual gender-based violence case instead of mocking them, the prosecutor who acts with fairness rather than expedience, the magistrate or judge who listens with empathy, the registrar who clears the backlog with diligence, the attorney general who defends the rule of law over any other expediency, the ministries that budget for justice as a necessity and not an afterthought. It also depends on the witness protection agency that ensures citizens can speak without fear, and on every one of us here, because every decision we make either opens or closes the doors of justice. But beyond institutions, access to justice lives and dies in the everyday realities of ordinary people. It's the rural woman who has to walk more than 30 kilometers to reach the nearest court. And so even when we have e-filing, physical courts are still a necessity, not only for the vulnerable groups, but also to ensure that those justice defenders are able to ensure that they can come and meet those vulnerable persons instead of just relying on virtual courts. Because access means real access, to be able to come and feel that you've gotten access to justice. This calls for intentional investment. We must fully operationalize the Legal Aid Fund, expand mobile court services, and strengthen public legal education so that citizens know their rights and how to claim them. Technology must also be leveraged to simplify access, from e-filing and virtual court appearances to digitized case tracking and digitized proceedings. We continue to suffer lack of access to justice when you cannot appeal for your case because there's no access to proceedings, or the proceedings disappear. Yet we're saying we are digitized. Also, we should be able to get proceedings online. Transparency and data sharing amongst justice actors can eliminate duplication and delays. And as well as the Office of the National Police Service, the IG, the continued challenge of the question of authentication of orders. I think that's a challenge we've fought last time in the NCAJ Council, and I don't know why it keeps coming back. Once court orders are issued, I don't know what process must authenticate again the court orders. Court orders are valid unless set aside, varied, or reviewed. And so telling a citizen that that order you cannot implement until it's authenticated at the head office, what is that process? Can it be done transparently and openly, and there be timelines so that people can feel that I don't have to pay for authentication of a court order, yet I went to court to get that order in the first place. As former US President Barack Obama said, the arc of the moral universe is long, but it bends towards justice only if we bend it. The work of bending it demands courage, resources, and unrelenting political will. The National Police Service and the Ministry of Interior should uphold that principle that security and human rights are not opposing forces. The Director of Public Prosecutions let discretion be guided by conscience and fairness. And to the Office of the Attorney General and the National Assembly on Justice and Legal Affairs, ensure that legal aid, law reform, and institutional funding reflect the urgency of justice that it needs. To the judiciary, continue bringing justice closer to the innovation, digitization, and mobile courts. And in the same breath, hold judicial officers who contravene statutes and constitution accountable. To all NCAJ members and partners, let this report not be another entry in our archives, but let it be our mirror, our mandate, and our measure of progress. In the words of Martin Luther King Jr., justice too long delayed is justice denied. Every time a child spends unnecessary nights in remand, every time a widow is evicted without recourse, or a protester is jailed for speaking truth, that delay becomes a denial, and that denial becomes a wound in our national soul. As the Law Society of Kenya, we reaffirm our commitment to the conscience of the justice system, ready to collaborate where partnership is possible, and to litigate where accountability is required. Let this be the year we move from rhetoric to reform, from commitments on paper to action on the ground. Let us unblock access by removing administrative obstacles, reallocating resources to where the need is greatest, and rebuilding public confidence in the justice system. To borrow from Justice Willie Mutunga Emeritus, the Constitution is a living document. It breathes through the actions of those entrusted with it. In this room lies many actors who the Constitution relies on for you to breathe life in it. Let us breathe in that life together. Asanteni.
Asante sana Rais wa Chama cha Wanasheria cha Kenya. Kwa hakika mpango mkakati unaopendekezwa